SJC-10267, Commonwealth versus Johnson.
Ms. King? Good morning.
Good morning, Your Honors. Rose King for the defendant, appellee Anthony Johnson. Your Honors, John Adams said, "Nip the shoots of arbitrary power in the bud is the only maxim which can ever preserve the liberties of any people." And this
Sounds right to me.
sounds right to me too, Your
Only if
Honor.
it comes from John Adams.
Your Honors, my client Anthony Johnson, on the date of this incident, August 29, 2006, was 17 years old. He was standing under a tree with 5 of his friends. The trial record shows that each of the children, I'm kind of old, so they're children to me, were African-American, are African-American. There were no reports of criminal activity. One of Mr. Johnson's friends was known, it's not that clear from the record, when it became known to one of the officers that he was trespassing.
Okay, what did it mean, trespassing? Trespassing on what?
It seems
An order outstanding.
Well, was there an order from where? I was just curious.
Yes, Justice Cowan. I think that what I got from the record is that he was on Public Housing Authority.
That's what I assumed, but that wasn't in evidence. That's just what I assumed.
It was I remember seeing it somewhere, Your Honor, but I don't exactly.
Okay.
You're not challenging the validity of the arrest of the defendant's friend for trespassing, are you?
I'm not challenging it legally, Your Honor. I don't have a basis to challenge it. I am challenging it morally because I just wonder why the police just can't ever leave these kids alone. But
if there's an
no.
outstanding trespassing order, one would hope that it would be enforced. I mean, those orders shouldn't be meaningless, but I don't think this is fundamental to your case.
I agree with you. Maybe a scat order would have, in my day in Dorchester, that's what would have happened. But aside from the trespass, there were no reports of criminal activity, no reports of any kinds of shots fired, no evasive action by the defendant, Anthony Johnson, when the police approached.
This was a high crime, high drug hotspot area?
That is what the officers testified, Your Honor.
And while the police officers are arresting one of these people, the defendant is sticking his hands in his pocket trying to find something.
That's what the record says, Your Honor.
I think that the record said he was digging into his pockets as if looking for something. I believe that was the finding. Is that right?
That is right.
Okay, so he wasn't just putting his hands in his pockets, say, to be warm. The judge found he was digging his hand into his pockets as if looking for something.
That is what the judge found, and that is what the testimony seems to show.
And you're saying that a police officer could not be reasonably apprehensive for his safety in those circumstances, where he might reasonably be concerned that that the defendant in this case was reaching for a weapon to prevent the officers from arresting his comrade.
Your Honor, I would say that under some circumstances, I think certainly that could raise the specter of dangerousness. I think what...
So the police officers told the defendant to take his hands out of his pocket. The defendant complied. That seemed to be okay. That seemed to satisfy the officers. Then he reached in his pocket again.
Yes.
And the police officer doesn't get reinforcement of of concerns for his safety at that moment?
Your Honor, I would say no, looking at the whole picture. And I guess that's my point of this sort of exhaustive list of what wasn't there. Like most of the cases cited, there really isn't a case exactly like this in Massachusetts. Most of the cases are at night or following reports of shots fired or one of the...
Why are guns any less dangerous in the day than at night?
Well, I don't think they are any less dangerous in the day and the night, but there was no evidence that this young man had any... Well, I think...
He's digging in his pockets. That's the evidence that leads to the worry in an area with drug dealings, gangs, gun violence, and property crimes. I gather that there was testimony that there were multiple arrests in the area, that the area was saturated with drug dealing.
Your Honor, you're right. Digging in his pocket as if looking for something.
Well, the trial judge found that there was some ambiguity. I think he or she wrote, such movements may be representing a danger to the police in seeking a weapon, or they may be for a variety of legitimate purposes. What degree of risk are we to impose upon a police officer before we allow that police officer to do a frisk?
Your Honor, I don't think reasonable people differ in the position that police officers should remain safe. So I agree with...
I'm sorry, I didn't hear police officers should...
Police officers should be safe. They should go to work and they should be safe. But I also don't think that the officer safety rubric should allow them, under facts such as these, which are really innocuous. He put his hands in his pockets.
No, he didn't. That wasn't the finding. The finding was that he was digging in his pockets, as if looking for something. What would the officer think that he could be looking for other than a weapon or drugs to, like, maybe throw them away? But what else?
Your Honor, an identification. I mean, the officer
He
had
hadn't been asked for identification. That was a different case.
Which I don't mean to be glib, but I think if he had a weapon in his pocket, he wouldn't have to, he'd know where it was. So it makes me think that as if looking for something makes his actions less innocuous than some of the cases talk about, a movement to the waist, or that's at night, a movement to the waist at night, I think, or a lunge or a furtive gesture. I don't think this was that. I think this was...
Do we know was it pants pockets, jacket pockets? Do we know?
I would think it was a sweatshirt.
Sweatshirt pockets.
Yes. Then somewhere I saw something about pants pockets too, but I think the judge found that it was sweatshirt pockets.
Ma'am, don't you think that at the point when he returned his hands to the pockets, after he had been told to take them out, that changed things? He had been told to keep his hands out of his pockets, and then he put his hands back in there. Now, what would a reasonable person in the police officer's position think? Something's going on here. It could represent danger.
Or it's a nervous tick.
Well, are we asking police to take that risk? Oh, it's just a nervous tick.
No, we're asking police to take into consideration all of the circumstances, though. And that's what I think we have here.
But they don't have to, they can do that, and they don't have to exclude everything but dangerousness. I mean, if this kind of activity would reasonably lead someone to believe that there might be danger involved, the danger in those pockets, that's all that's necessary, isn't it?
No, I don't, Your Honor, respectfully, I don't think that's all that's necessary.
So the police have to consider all possible options and eliminate everything except dangerousness.
No, they don't have to eliminate everything except dangerousness, but they have to use their judgment. And I think that that's the point here, is that, no, there are some circumstances where perhaps the mere fact of putting your hands in your pockets after you've been told to remove them, and certainly there's case law to support this, that a reasonable police officer, given those circumstances, would have found that the person was armed and dangerous. But I don't think in this case, and I think that the police officers, before they put their hands on someone, I think they need to, when you read the transcript, there was no, there just seemed to be nothing from the circumstances that raised the specter of danger. So really what you did have that this was a known gang area, drug area. The police officer testified to that. However, he also testified that he was in this area once or twice a day, and he didn't know this defendant. So it seems to me that police officers, I mean, I practice in Dorchester, and so I hear all the time that police officers, they know the players. I can only imagine it's the same thing in Springfield. But they didn't know this kid. So I would imagine, even though the officer testified that this was a gang area, that this Anthony Johnson wasn't a part of that. So they came upon these kids hanging under a tree at 11:30 in the morning. What are you doing? We're just hanging out. One of them wasn't supposed to be there. So they arrested him. Certainly legally they were entitled to.
Well, I take it you're looking essentially at Commonwealth versus Frazier and saying this is very different than Commonwealth versus Frazier.
Yes, Your Honor.
The court in that case said a pat-down was justified where the police were responding to a radio call describing a man with a gun. The encounter occurred in a high-crime area. This is at night. They observed the defendant. When they get there, they observed the defendant bending down behind the truck as though to pick something up, and then he put his hands in his pockets, and that those were the factors that caused the police to pat frisk him, even though they had no reasonable suspicion to believe that he was committing a crime.
Yes, Your Honor.
And you're
But
saying,
Sorry.
good. So this case, you say, is different than that.
Yes, Your Honor.
You do have a refusal to remove hands from the pocket. You do have him digging in his pocket, sweatshirt pockets for something, and you do have it a high crime area. So what is the fact that's different? Just that they weren't responding to a call about a violent crime or a weapon?
It's daytime also.
It's daytime,
Daytime?
but I think that that's huge. But he didn't, Your Honor, respectfully, he didn't refuse to take his hands out of his pockets. And there's a case about that also. He took his hands out of his pockets. And then he put his hands back in his pockets.
And by the way, I refreshed my memory as to the findings. The judge said that the officer had seen him digging into the front pockets of his sweatshirt and jeans as if looking for something. So that was unclear a moment ago. But
Yes, thank you, Your Honor.
I'm just asking you what a reasonable police officer would think. You said maybe he was looking for his ID, but I mean, I can't imagine. He could be looking for keys. I can't imagine why. He could be looking for an aspirin, but I can't imagine why. I mean, he could. It seems the only thing he could be searching for that it's reasonable to believe is a weapon or, as I say, drugs to get rid of them.
But, Your Honor, respectfully, I don't think it was drugs to get rid of because the police officer was right there.
Well, that's right. So that leaves a weapon.
But I don't think so because I still think that if he had a weapon, I don't know. I've never carried a weapon, but I'm just saying you probably know where it is.
Yeah, but it's an objective standard. What is the police officer, a reasonable police officer, supposed to believe?
Absolutely. What is a reasonable police officer supposed to believe? In the absence of any other dangerous indicia, any other indicia of dangerousness, what is a police officer supposed to believe? That this kid is nervous. So he puts his hands in his pockets. Take your hands out of your pockets. Take your hands out of your pockets. I just don't think it's enough for the police officer. I mean, it's not that I don't think it's enough. I don't think it's enough. But I don't think that the case law supports this position. But I also don't think that there is really any case law that is completely on point with this issue, given the fact that the cases really do seem to occur at night or with reports of shell fight or a bulge in
You
the
haven't
clothing.
yet told me why at night is different from in the day. Why is the danger any different in the day than at night?
Because people might be more willing to use a gun.
At night? Yes.
They can't be seen, they can't be recognized as easily.
That's what I think too, and I also think that that again you look at the whole picture. It's just a different kind of. I mean, these were just teenagers hanging out in the morning, so let's just give them the benefit of the doubt. This is just some teenagers hanging out in the morning. They happened to be in a place where the police testified that there were gangs and drugs, but yet they didn't know my client, even though they ride through. I think you have to take all of these. I mean, I can't tell you what to do. You can do whatever you want, but I'm just saying, I just think it's right to take all of these conditions, and I think it's just too easy to say, well, he put his hands in his pockets, so the police had the right to put their hands on them. I just think that the police power needs to be checked. The police need to be kept safe. I agree with that. But we have to trust them to take all of the circumstances and put them together and determine if it's reasonable to assume that this kid, who didn't do anything but put his hands in his pockets after being told to remove them, was armed and dangerous and should have had his hands, had his body, have the police officer put his hands on him. Your Honors, thank you very much for your time.
Thank you, Ms. King. Ms. Levy?
Good morning, Your Honors. May it please the Court, Sidney Reevy representing the Commonwealth in this matter. I'm asking the Court to reverse the lower court's allowance of the motion to suppress because there was here an objective, reasonable suspicion on the part of an officer with all of the totality of circumstances facing him on this day in August to believe that the defendant was armed and dangerous
How many
and
police
to conduct a
officers were
pat.
there?
I'm sorry?
Was he alone, the police officer?
No, there were two officers, Officer Van Zant and Officer Walter. They were part of the Springfield Street Crimes Unit. They patrol this area 1 to 2 times a day and evening because it is such a hot spot. As the motion judge found, it was replete with drug dealings, gang involvement, and property crimes. Both officers had made multiple arrests in the area and were familiar with the areas, particularly 21 Girard Street, the apartment building where the kids were standing, is known as both knew it as a gang member and drug dealing hangout. As they approached, they observed the defendant. They were approaching an individual who had a trespass order out against him and observed the defendant digging in his sweatshirt and jeans pockets as if looking for something. When asked to remove his hands, he did. He briefly complied and then immediately returned them. Officer...
How many people were in this group?
Six, including the defendant.
Had the arrest of the trespass, had that happened before this or after?
I'm not clear. My feeling is that they were simultaneous, that one officer is dealing with the trespass individual and Walters is watching. Actually, Van Zant said to him, watch his hands, something like that. And when the hands were returned, Officer Walter seized the individual's hand and pulled it out of his pocket. He said, I'd rather detain him and stop him from shooting me or from him shooting, or from me shooting him. He said that he would do this. He would have approached any individual in this area in the same manner.
Let me just ask you some questions about in this area. Would you agree with me that everybody who lives in a high crime area is not necessarily a criminal?
Absolutely.
Right. And part of what we try to do here is to balance the rights of people who happen to live in a high crime area for which they are not responsible, often don't have any options. And I just wonder how we would look at this if we took out all of the evidence of high crime area, drug dealing. Would it make a difference, or are we essentially saying we have two constitutional standards for citizens in our society? If you have the misfortune to live in a high crime area, you're subject to one course of conduct by the police. If you happen to be fortunate enough to live in an area which is not high crime, you're subject to a different course of conduct.
I believe that the conduct that was displayed by the defendant, his actions had he been in downtown Wellesley or Boston,
so
would have...
we would be free, according to the Commonwealth, to take out all of the evidence of high crime area, prior drug arrests, because they didn't have any basis to suspect any of these children other than the fact that there was one trespass and that you could get in Wellesley. And then assess the circumstances.
Yes,
Is that how we should set the constitutional test? So we just ignore Not ignore. but
Not ignore.
No, ignore for constitutional purposes. Otherwise, we've got two sets of circumstances.
Exactly, yes.
So
Yes,
we
Your Honor.
take out the high climb and the...
And I think the reasonableness of the suspicion of danger would be the same.
Really? Is that really true? Just a bunch of kids at noon hanging around. One of them has a trespass notice. The police go over to apparently ask some questions to get their identifications. One of the kids got his hands in his pockets, shuffling around in his sweatshirt pockets. Take your hands out, takes them out, and puts them back in. You're saying that's a basis for the officer to believe that the defendant is armed and dangerous, such that a pat frisk is warranted? In the middle of the day in downtown Wellesley? Or?
Well, the Fourth Amendment it circumscribes that type of search. It has to be reasonable. There have to be specific,
Well,
articulable...
isn't the fact that this is a high-crime area, whatever that means, and it's certainly an overused term, I think all of Boston is a high-crime area, depending on what definition you want to use, but isn't that important in looking at the situation through the eyes of the officer?
I don't believe so. As long as he has a reason to be in proximity of the individual, you know, he can't just approach everybody on the street and say, you know, take your hands out of your pockets.
But you said that he said, I mean, certainly it was in his mind that exactly where he was. I mean,
This is a dangerous area. There have been shootings here. There are people
Yes.
around here walk armed all the time. We know that from prior experience. Isn't
And
that-
this house is one that we know to
It's
be
a
a
hangout.
place that's a hangout, and they've sold drugs out of this house.
Isn't that
That's part of the record.
Yes.
How old?
Not that there were that there were drug dealings and location for gang members to hang
were
out.
they in the yard on the...
They were outside of the building.
No, but I mean, I'm trying to understand the trespass. Were they on a public way?
I don't know that, Your Honor.
Well, it makes a difference, because how do we connect them
They were
to-
in front of 21 Gerard Street.
I understand,
You mean
but...
on the tree belt or the front yard? I don't know. I don't know.
So, again, how do we know that these children knew what was going on 21 Gillard Street?
I don't think that's relevant to the officer's suspicion of his danger, his safety.
Did anybody contest the lawfulness of the trespass or the arrest?
No.
How old? Was there evidence as to the age of the judge calls them young people? How old were they?
I don't recall.
How
I
old
don't.
was the defendant?
I was 17.
Not a child.
No.
Considered an adult.
But, Your Honors, I would argue that this case it fits precisely within the borders of Commonwealth versus Frazier, in that the totality of circumstances in that case led the officer to reasonably believe that the suspect was armed and dangerous when he, after being told to remove his hands from his pockets, returned them after a suspicious movement of reaching for something or picking up something.
But you don't think that the facts that Justice Cordy went through, the differences, nighttime, reports of shots, reaching down, putting something down, getting up behind a car, you don't think that's a little different in this case?
It's a little different, but no, I don't feel it's any different than Commonwealth versus Gowie, Commonwealth versus Nunez. The same suspicious behavior has to be resolved. The
So
ambiguity
whenever, wherever somebody puts his hands in his pockets,
after being told to remove.
that is grounds to pat frisk him or her.
Yes, I think you have to err on the side of the officer who's in close encounter, street encounters, traffic stops with society, and they have to be ready in split seconds to make judgments. And in that split second, if he's having to weigh the innocence or sinisterness of the gesture, it could cost him his life, which was what was said in Commonwealth versus Gowie, that an officer should not be required to bet his life on the possibility of an innocent explanation. And and an officer should not have to wait to see if a gun is drawn. That was in Isaiah I, because the answer might be a bullet.
Well, let's assume that we've got these facts and the officers stepped up and basically said, all right, everybody take your hands out of your pockets. They're there to presumably make inquiry with respect to this trespass.
Actually, didn't they testify that they were there to identify and check for warrants?
Yes.
Yep.
Check IDs, which is what they do on patrol every night, because it's such a bad area.
They stop and ask everybody.
Well,
So downtown Wellesley, you're returning from the movies, 1 o'clock afternoon. I know you're not, but somebody is. And please stop. And they routinely do this. They sweep through Wellesley and they stop and ask for IDs. And
well, they don't routinely sweep Wellesley, nor would it be logical that they would do so. But if there was a circumstance,
I'm just asking whether the constitutional standards and protections apply differently because you happen to live in a high crime area.
no, it's one factor that adds to the reasonableness of the suspicion.
Then it's different.
It's different and the same.
All right, so we've got 6 kids at noon on the sidewalk or out in front of an apartment complex. Police coming up to check IDs. They say, everybody take your hands out of your pockets. Someone doesn't. That pat frisk time? No other
Yes.
information. We don't have any reason to believe these people are drug dealers or carry weapons or anything, but that's okay because they didn't take their hands out of their pockets?
Yes, that would be the Commonwealth's position. That is
Oh, boy, that's-
inherently a risky, suspicious gesture in the eyes and in the experience and training of officers whose judgment is how the prism that we have to look at these gestures through.
Well, they don't know anything about these kids. In my example, they don't know anything.
No, they know about hands. Hands are the key to their safety. They're in seeing hands is indispensable, as is seen through all the cases so far. Commonwealth is Gowie, Nunez, Pagan, Foster, Nestor. All the inability for an officer to see the hands could cost him his life. And so
But
far,
you've got no reasonable suspicion here.
what is it?
You have no reasonable suspicion. So essentially what you're saying is that when officers have no reasonable suspicion to suspect citizens, residents of a crime, they can go up to them, tell them to take their hands out of their pockets, and if they tell them to take their hands out of their pockets and they decline to do so, they can pat frisk them.
Again, the Fourth Amendment requires a degree of reasonableness. You can't just go up and I just don't think it
What do you
wouldn't
mean
be.
you can't just go
I
up?
thought
Isn't
you
that
said
what-
these police officers routinely approach and do ID checks and
in
warrant
this
checks.
in this area because of the saturated violence and drugs in the area. But I don't believe you could go up to anyone on the street and just check for IDs. You could. The law says that you can, but
Well, we're not sure about that. The law says you can ask questions.
you can ask questions. If the person's hands are in their pockets and they're asked to remove them, then a law-abiding citizen would. I think
No,
the very
because you say a law-abiding citizen would, because then that gives the suggestion that the officer is entitled to stop any person anywhere with no grounds for suspicion and order them to take their hands out of their pockets.
Well, that would be poor police work. I think that would be unreasonable and would not fit.
I can't tell you what good or poor police work is because that's not what I'm asked to look at.
We're looking at the reasonableness of the approach and the reasonableness of the response to the gesture. And where there's an ambiguity, as there was here, and a refusal to remove the hands, then I believe that the officer is able to use the least intrusive means to resolve the ambiguity. And I'm asking the court to resolve the ambiguity in favor of the officer's
Do
life.
you have the citation, please, for Commonwealth versus Goey?
It's in my,
Well, there isn't real, well, it's because,
it's in my brief, Your Honor.
yeah, it's cited in your brief, but it just gives, it doesn't give a very...
Case number. Doesn't
Case number. It
say.
just says, the date, SJC, case number such and such, and 2008, but you don't, so you don't have any better citation.
Not in front of me.
Okay.
I will get
Fine.
it to you, Your
Thank
Honor.
you.
Even if the officer is wrong here, the intrusion on an individual is minimal by comparison with the danger to the officer. Thank you, Your Honors.
Thank you, Ms. Levy.